Hello and welcome to another episode of the Mourant Vlog Series. Today, Lily and I want to talk about an issue that we are seeing more and more often. That is, beneficiaries demanding that their trustee resign. Now, we've had a couple of cases just this year alone where trustees have sought our advice about how to deal with beneficiaries who ask and sometimes demand that they resign. Usually there is a catalyst, be it the trustee refused to make a distribution or some disagreement arose about fees. No matter the cause, being hit with a demand to resign is never pleasant and it must be handled with care.
One of the bigger matters that Alexander and I have advised on recently involved a trustee company that was asked to divide the trust fund between the beneficiaries. Despite months of consultation with the beneficiaries, a division that was satisfactory to all of them could not be agreed. One by one, the beneficiaries got fed up with each other, and unsurprisingly, that turned to dissatisfaction with the trustee, who they ultimately asked to resign.
The complicating factor in this case was that not all the beneficiaries asked the trustee to resign at the same time. Initially, a majority did, but some specifically asked the trustee to remain. So what does a trustee do in this situation? Well, the starting point is always to look at the trust instrument to see if it contains any provisions dealing with what a trustee must do if asked to resign. Rarely have I seen such a provision, but the trustee must check the trust instrument just to be sure. If there is no provision or process in the trust instrument, then we turn to the law. Now, as far as I'm aware, there is no rule in trust law or the general common law that requires a trustee to retire at the request of the beneficiaries. As such, it is useful and perhaps prudent to consider the case law regarding removal of trustee applications when looking at whether there is justification for a trustee to resign. The case law on this point essentially provides that when deciding whether a trustee should be removed, the most important consideration is the interests of the trust as a whole. This means the welfare of the beneficiaries and the administration of the trust in their favour. Now, interpreting this in the context of a trustee falling out with beneficiaries can sometimes be tricky. It is worth noting that 1. Friction between trustees and beneficiaries is not of itself a reason for the removal of a trustee. 2. Friction can often lead to management of the trust being more expensive and slightly slower as trustees deal with the concerns raised by the beneficiaries. However, just like the first point, such factors should not themselves justify removal. And 3, the court focuses on the welfare of the beneficiaries of a trust, not whether such persons would be better off if they managed the assets personally. Often dissatisfaction on the part of the beneficiaries can arise not so much as to how the trust is run, but because the beneficiaries would prefer to run the show themselves.
There are also some situations where it would be sensible for a trustee to remain in office despite requests for its retirement. An example is when a trustee is midway through a big task or a transaction.
Ultimately, each case is different and has different facts. In deciding whether to retire, the trustee should consider whether it is of the view that the breakdown in relations between it and the beneficiaries is obstructing the administration of the trust. If the trustee answers that question in the affirmative, then it should further consider whether it is in the best interests of the beneficiaries as a whole for it to remain as trustee. If the trustee decides that it should retire, then it must also make a decision about who to appoint as the new trustee, if of course there is not already a co-trustee.
In practice, the beneficiaries will usually just agree the appointment of a new trustee. However, it is still important for the retiring trustee to exercise its power of appointment properly and to document this.
Yeah, that's right, Lily. That is actually a very good point. The power of appointment must be exercised in accordance with the trustee's duties. In order to properly discharge this duty, the trustee should obtain some level of due diligence. This can usually be done by writing a letter to the proposed replacement trustee requesting that it provide 1. Details of the jurisdiction in which it is incorporated. 2. Confirmation of whether it is regulated and if so, the authority that regulates it. 3. Confirmation that it has adequate professional indemnity insurance in place. 4. The name of its directors together with an overview of their relevant experience in relation to the administration of trusts. And 5. Copies of its constitutional documents. The point of this exercise is not to be difficult or to drive up the costs of retirement. It is important to document the inquiries as evidence that the trustee has properly performed its duties. If the incoming trustee cannot be agreed, the trustee should first exercise its discretion to appoint a new trustee after completing its due diligence, and then should consider the prudence of getting the court to sanction the proposed choice.
Friction between beneficiaries and trustees can be a big issue, and when it escalates to demands for retirement, it is important that trustees approach every aspect of the process with care, right down to the correspondence that it sends to beneficiaries. If there is anything in this episode that you would like to discuss with me or Alexander, please give us a call. Thank you.
Thanks.